Ladies and gentlemen, the Supreme Court, when it gets this case, will side with Trump. And I have been telling you exactly what's taking place, or exactly what would take place and what will take place every Supreme Court challenge. Hit subscribe to this channel right now. In a couple of seconds, you will hear exactly why the Supreme Court will overturn a very absurd conviction on a federal statute that wasn't named within the indictment or the conviction. It was a reference to a broad range of federal laws that Trump allegedly broke. I don't believe, now you can correct me if I'm wrong, I did not see a statute in the initial indictment, and I don't believe the court in New York cited a specific federal statute because the Department of Justice and the FEC dropped the case. Hit subscribe to this channel right now. You will hear in a second. And Paul Bartlett to my super chat, thank you very, very much. You will hear in actually right now, let's listen to this, John Yoo explaining exactly what I'm talking about. A state cannot level a federal crime without the Department of Justice and the federal government involved. Trump is 100%, just like I told you, the Colorado ban would be overturned. The immunity victory, he would get an immunity victory in the Supreme Court. I'm telling you right now that the Supreme Court's going to overturn this very absurd, invalid, constitutionally invalid conviction. This is John Yoo. Hit subscribe to this channel right now to my super chat. Thank you. And what can I tell you? It's pretty. You don't have to be a legal scholar. Here's a legal scholar, though, explaining this.
I appreciate what you said in your opening statement because the Supreme Court has made clear, not just in one offside comment, in three very clear decisions, that only the federal government can enforce federal law. Only the Justice Department and the Federal Election Commission can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election should run. And so what happened here is that the DA, approved by this judge, Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
When we come back, John Yoo,
That is exactly what I've been saying, ladies and gentlemen. Check this out again.
Federal law. Only the Justice Department and the Federal Election Commission can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election should run. And so what happened here is that the DA, approved by this judge, Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
The Supreme Court will reverse. There's no doubt about that. Let's listen to it again.
And basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
So, ladies and gentlemen, it's pretty clear cut. It's already a done deal. The Supreme Court will reverse. They will hear the case, even if the judge doesn't give Trump any jail sentence. So it's likely going to be a sentencing, but no jail sentence, a conditional sentence. And I talked about that yesterday. Hit subscribe to this channel right now. Every single Supreme Court challenge, even the January defendants, you had Justice Jackson siding with Trump on the egregious sentencing for the January defendants. That's one victory. You have the Colorado ban being overturned. That's another major victory. And the greatest of all, the Colorado ban and the immunity victory, those three victories I just mentioned right now. The January defendants, but especially the Colorado ban and immunity being reaffirmed by the Supreme Court. And I told you, especially with the Colorado Supreme Court decision, I said before it happened, it would be unanimous. This too will be a unanimous decision. I think it'll be almost entirely unanimous. You cannot rewrite the Constitution. The system of federalism is outlined in the Constitution. I believe it's the 10th Amendment, but you can go ahead and correct me if I'm wrong. But a state cannot simply decide unilaterally what federal law entails. This is not, you don't have to be an expert. You don't have to be a rocket scientist. You don't have to be a legal scholar. This is pretty obvious. The DOJ dropped the case. D. Lynn, thank you. The Department of Justice dropped the case. Okay, let's just listen to John Yoo again, and then we'll hear some more legal analysis, especially from Clarence Thomas.
He decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
Now you're going to have Clarence Thomas, and Clarence Thomas took them to task with the immunity issue and also with the Colorado issue. But the oral arguments, Clarence Thomas, Alito, John Roberts, Amy Coney Barrett, Neil Gorsuch, they all knew that there's so much politics involved, and there's not the Democrats in the Colorado fiasco banning the state Supreme Court banning Trump in the most ridiculous decision. They basically tore up the U.S. Constitution and said, well, we think he committed a rebellion. Oh, well. Now Democrats are saying, we think that he committed a federal campaign finance law violation. Oh, well. You can't do that. You can't do that. And also, he's protected under immunity, presidential immunity, especially with some of the evidence that was given during the trial. So if you have a good it was either Hope Hicks or some other discussions, either discussions he had with Michael Cohen or discussions he had with Hicks, potentially, possibly, or with other staffers that they utilized against Trump during the New York trial. Well, guess what? He's protected under presidential immunity. You simply can't take conversations that aren't recorded out of context and accuse a president of committing a crime simply because that's your recollection of the discussion. We know that now from the presidential immunity ruling. If he was engaged in official acts, and speaking to an attorney, speaking to a staffer is an official act, even if the conversation starts off on national security issues and meanders off into other issues, it's still an official act. You can't delineate when a private conversation between a president goes from the public good to private interests. It's impossible to do so. Go look at the Nixon tapes. Well, I mean, it's all personal interest, it's all private, but then he talks, there's a lot of discussion of national security issues. But anyway, listen to this. This is Clarence Thomas taking the federal prosecutors to task.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article II branch, can assert, as applied, Article 2 objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions. That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which has never happened in our history. And we submit that is not necessary in order to assure that the president can perform all of the important tasks that the Constitution reposes in him.
Why wouldn't Democrats want conviction in the Senate? Because they know that the impeachments they've leveled were purely political. Okay? If it's such an egregious act that all Americans or most Americans are outraged, not just the typical, usual, endlessly indignant, morally superior liberal Democrats who ignore the criminal activity and corruption within their political side and then pontificate and preach and lecture about corruption of their adversaries. I'm talking about you would want. So the Jack Smith's counsel here, the prosecutors, are trying to say, well, we want to remove presidential immunity from Jack Smith's indictment because, well, we've accused him of lying in a speech, and that lie fomented a rebellion. These are the absurd, outlandish, very stupid leaps of logic that very intelligent, wonderful, morally superior liberal Democrats engage in. He told a speech, he lied, therefore, he wasn't doing the public good, he was doing he was speaking on behalf of himself. Well, was Biden speaking on behalf of himself when he lied for 3 weeks straight, saying that he was going to stay in the race, man? He's going to stay in the presidential contest, man. And then he relinquished he stepped down from running. And then Harris lost the popular vote to Trump because Democrats don't even have functioning primaries, yet they pontificate about democracy. They railroaded and cheated Bernie Sanders, and they did the same thing to Biden. But the point, ladies and gentlemen, is that they don't want conviction in the Senate after impeachment. They've impeached him, what, twice? They would have impeached him 30 times. But they knew that all 30 times he wouldn't be convicted because he didn't really commit an actual crime. Bill Clinton lied under oath. But nobody was really going to convict him in the Senate for lying under oath about something that took place. Oh, there you go again, bringing up bad memories. Nobody was going to convict him for what took place in the Oval Office with Monica Lewinsky because the country didn't find that didn't reach the point of the height of criminality. Even though he did lie under oath, and that's a felony.
Over in not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions. Yeah. Why? If what you're saying is right, it would seem that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure.
Now, that's a very interesting mentality because these are the same Democrats who would say, well, an international court, sure, let's go after international leaders. Well, of course, they've broken international law. But the Jack Smith defense here is, well, they weren't crimes. They were presidents in the case he's talking about with, possibly engaged in international conduct that could be viewed as criminal. But they didn't break U.S. law, so what's the problem? and And a lot of Democrats disagree with that viewpoint, but not when it comes to Trump. So anything that President Obama or Bush, Cheney, and Rumsfeld did, totally fine. But a speech, Trump's speech, where Democrats literally less than 4 years later ousted the most popular candidate. Biden was literally the most popular candidate of all time. And then they expect everyone to believe that they just simply can oust him before his tenure is up, remove him from the presidential contest, replace him with Harris, who polled lower, who lost the popular vote to Trump in every battleground state. And Trump's words that day, in disbelief that he had lost fair and square, this is a blasphemy beyond belief. His words, questioning the sanctity of the outcome 4 years ago, entered into the mind of impressionable Trumpers, and then they tried to rebel against our nation. And then only Democrats can protect us from another Trumpian rebellion. Therefore, we have to imprison Trump because his speech was not protected under presidential immunity. And the justices are like, what are you talking about? Presidents have done infinitely worse on the international stage. They haven't been prosecuted. What are you even saying? Oh, Jack Smith is saying, well, wars, intelligence activities, even taking out foreign officials. That's not breaking U.S. law, but a speech is breaking U.S. law. It's like, no, it doesn't really work that way. That's why the Supreme Court overruled this. The Colorado arguments are even more hilarious, and we'll get to that in a second with Clarence Thomas.
That former presidents do not have to lightly assume criminal liability for any of their official acts. At the outset, there is a statutory construction principle that is applicable here. It arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access to advice from the attorney general, and it would be a due process problem to prosecute a president who received advice from the attorney general.
They would simply indict the attorney general. Because they would have indicted William Barr also, or they'd indict any attorney general back then that Trump had that gave him any advice. If an attorney general said, yeah, you can contest the outcome, then that person too would have been indicted. And they would have tried to convict that person as well.
That his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option. And then if I could say one more thing, because you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas.
So at the end of the day, of course, the Supreme Court ruled against this view of presidential immunity. In fact, they strengthened presidential immunity. They reaffirmed that Trump and every future president can say whatever he or she wants, and you can't imprison them for that, okay? We know this because of a huge victory that I told you would take place.
Commercial break, because we have word that the Supreme Court has issued a ruling on the extent of presidential immunity from criminal prosecution for conduct alleged to involve official acts during the tenure of President Trump. This is the big one we've been waiting for. It's consequential. It's really interesting that the Supreme Court in 248 years of our history has never actually ruled on this. So it is big and sweeping. And I have our political panel looking over this right now. Andy McCarthy, Chief Justice John Roberts has the writing on this. He's got the pen. Is that significant?
It's very significant. It's the most important case of the term in terms of the long-term interests of the executive branch, in terms of the short-term interests of Donald Trump. And it looks like, at least within the bounds of clear executive authority, what Chief Justice Roberts is saying is that the president clearly has immunity from prosecution. So the question is going to be, again, I think Trey underscored this before, is what is an official act?
So, of course, in the usual apoplectic, morally superior hyperventilating of, highly intelligent, almost always hysterical, very moral liberal Democrats, many have said, oh, well, that means that Trump can take out his political rivals. That's not an official act, genius. Targeting an adversary wouldn't be an official act. What would be an official act is a speech. It doesn't matter whether he tramples upon the sanctity of 4 years ago, of Biden being the most popular candidate of all time. Okay? If you're a liberal Democrat and you believe Biden's the most popular candidate of all time, then answer why he was removed after one debate for somebody who polled lower than him. But let's continue.
Going to be a lot of litigation about that and what's close to the core of clear executive constitutional authority versus the outer ambit of it.
Brett?
Do we have Shannon? Is she going through the paperwork? Shannon, you there?
Yes. Yes, I am here, if you can hear me. Let me read you a little bit of what we have from the court. It does find this. Under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. He is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. That's the first blush we've got on this. It looks like a 6-3 split. We've got the dissent.
Speaking to a staffer, an advisor, or an attorney or a lawyer or legal staff is an official act. End of story. That's what they used against him in New York. So he could cite, Clarence Thomas will very likely cite presidential immunity as one of the reasons to overturn the state conviction. But I think I think it'll probably be unanimous or either, 7-2, 8-1, it should be 9-0, unanimous. A state cannot level a statute, like John Yoo stated, a state cannot level a federal statute, okay, against a state cannot level a federal statute against anyone without the federal government involved. The DOJ and the FEC dropped the hush money case. They dropped the hush money case because there's no evidence Trump committed a crime. Yesterday, we talked about there's numerous examples or numerous FEC chairmen stating, Bradley Smith, Hans Avon Spagowski, Trey Traynor, all stated he did not commit a Federal Election Act violation. Okay? And he did not commit a FEC violation.
By Justice Sotomayor, Kagan, and Jackson joined that. There is a kind of split decision on some of these. Somebody joins in one part, not in another part, but that's the overall holding of the court. So what it means now, we'll have to dig into this and see if they tell us now, how do you decide an official act versus an unofficial act? Because that's going to be critical, having now said the president does have absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. We'll dig in, see how they define those official acts, and look for a little bit more from you from the opinion. But at first blush, this looks like it is going to be a win for the argument for presidential immunity when it comes to allegations of criminal activity.
Ladies and gentlemen, if you're new to this channel, hit subscribe right now. I told everyone for the past year, Trump would get the presidential immunity victory. Trump would get the victory over the Colorado Supreme Court, overturning the Colorado ban. I am telling you, and I told you he's going to win re-election. And I said it would be, a wonderful, overwhelming victory. I even used the word landslide many times. But ladies and gentlemen, I'm telling you right now that the sentencing, if you look right now, they are having a good time. He's very angry, CNN. He's very angry, so angry. He won the popular vote, every battleground state. He has the Senate, the House, the presidency, and a 6-3 majority in the Supreme Court. And thank God he survived an attempt on his life, and God bless that family. I mean, a firefighter lost his life that day. And every American on the, in the country should remember that. A man lost his life that day when there was an attempt on Trump's life. And he's alive now. Thank God, Trump. And I wish that God works in, mysterious ways or ways that we don't understand. And it's like, I believe in God, but then it's like, thank God Trump was saved. But then what happened to that man defending his family? Okay. But that day, God was with Trump. He moved his head and he survived. Thank God. And so now we have a whole new ballgame, but media is still the same. CNN, he's very angry. Political Trump rails against justice system. So it's the same playbook, but he's just going to continue to rack up victory after victory. Then media. Now my next prediction is that media is going to become more conservative, and you'll see that. You will see that, and that'll be absolutely hilarious. But this is all that has to happen. What Mark Levin is saying here, they've probably already petitioned the Supreme Court using what Mark Levin is talking about, but all that has to happen is what Mark Levin is saying here. It'll go to the Supreme Court because a sentencing of Trump, he's still on the hook legally, where the state of New York could still try to torment him. He needs the entire conviction overturned. He cannot, even if there's no jail time, there shouldn't even have been a conviction. There shouldn't even have been a trial. So the fact that there's no jail time doesn't mean anything. But let's continue.
Donald Trump and his lawyers would be asking the Supreme Court to do. Why? These are federal law, federal constitutional violations, federal jurisdictional violations by an acting state judge and a prosecutor, by two people. And it's ongoing. Sentencing and other issues have to be decided by the local judge, and then the appellate level, and then the level after that. This is an ongoing violation. It doesn't even matter what the final court has to say. Again, if I'm Donald Trump's lawyers, I go through that process, but you go to the Supreme Court of the United States. Now, how do we get to the Supreme Court of the United States? This is where people get bogged down. There are writs at common law, and it really doesn't matter which writ you follow. Here's a piece by former Attorney General Griffin Bell. He would later become Attorney General under Jimmy Carter. In the Southern Methodist University Law School Law Review, the federal appellate courts and all writs. And it discusses what these common law writs are. Now, it discusses it in the context of a specific statute, the All Writs Act, that was passed as part of the original Judiciary Act in 1789. Not to get into the weeds, we're smart, we can follow this. The peremptory common law writs are among the most potent weapons in the judicial arsenal. These common law writs are used. They're rare, but they're used more and more within the federal chain of courts. So what does he say here? Well, the basis for general judicial supervision over inferior courts, inferior federal courts, through extraordinary or preemptory writs can be found in early common law. The All Writs Act is a direct descendant of the Judiciary Act of 1789, other than the Supreme Court, which is created by the Constitution. Everything else is created by Congress. All the other courts, the number of courts, how many justices are on the Supreme Court. It granted federal courts the power to issue extraordinary writs in aid of their respective jurisdictions. And while it is clear that the All Writs Act authorizes the issuance of the traditional common law writs of mandamus and prohibitions, the phrase all writs also encompasses common law certiorari, injunctions, subpoenas. Don't worry about all that. What that really means is there's many ways of characterizing this direct appeal to the Supreme Court and relaying the facts and relaying what's taken place under the law to the court.
So, ladies and gentlemen, it has essentially already been overturned based on the precedent. This isn't very difficult to see. Hit subscribe if you're new. Clarence Thomas will be at the forefront, at the head of all of this. I think also Samuel Alito. I think John Roberts will even get on board like he did with the Colorado issue. This is Clarence Thomas. This was a unanimous reversal of the Colorado ban. Check this out.
Examples, because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for
either run for state offices or national offices. So it seemed that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
If you're looking for a house, you
Example I gave, no, but again, Your Honor, that's not surprising because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting
So what's the purpose
officer.
what was the purpose of the Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates.
So you're simply going to ask, when it gets to the Supreme Court and you have New York State prosecutors, Clarence Thomas will ask, what are the examples of a state unilaterally deciding or evaluating or interpreting federal law without the Department of Justice involved? This has already taken place. Clarence Thomas has essentially basically already overturned the case. If you look at the oral arguments in the Colorado decision and also immunity, he continually asks, well, where are the examples of a president being convicted on an official act? Where are the examples of a president being taken off a ballot? And then Democrats or the legal counsel has to say, well, this is what we think would have happened if Trump existed back then. But that's not enough. Because every single person, every single justice, even the liberal justices know that politics is involved when it's about Trump. They unanimously 9-0 sided with Trump here. Because there was no example in U.S. history of a presidential candidate being thrown off the ballot because of what a state believes he did or she did or he did. There's no examples of this in U.S. history. So Clarence Thomas has already ruled on this, essentially.
Candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War, and there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is, do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that Do
you have any examples in U.S. history? No, Your Honor, but many liberal historians have backed our viewpoint that Trump is a menace that must be dealt with. Oh, it's like, where are the examples? They're not going to set precedent based on the intense dislike of Trump by Democrats. That's not how legal precedent will be set in our country. And it's not. Democrats have tried and failed desperately to make Trump a legal precedent. If anything, it's strengthened Trump. Like, literally everything Democrats have done legally against Trump only made him stronger.
The idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s. And by the 1890s, everyone had received amnesty and these issues had become moot. So I don't think the history tells us.
Sort of look at Justice Thomas's question sort of from the
Colorado Supreme Court did, and let me mention, and up to the moment that an ineligible candidate was sworn into office. Nothing in the Constitution strips the states of their power to direct presidential elections in this way. This case was handled capably and efficiently by the Colorado courts.
It was unanimously overturned by the Supreme Court. Even the 3 liberal justices sided with the conservatives, sided with Trump to overturn the Colorado ban.
Under a process that we've used to decide ballot challenges for more than a century. And as everyone agrees, the court now has the record that it needs to resolve these important issues. I welcome your questions.
Is there an express provision with respect to that defines what a qualified candidate is?
No, Your Honor, there's not an express provision. When the Colorado Supreme Court looked at this, they looked at the need to be qualified, plus the fact that this part was...
So what does it say then? If it's not express, how do we get to this issue of qualified candidate?
Tear up your car insurance bill and try...
The Colorado Supreme Court did, and if I could have a standing objection, I do want to make the argument that you shouldn't review the court's statutory interpretation.
No, I'm just looking at the statute.
Right. What the court did was to say that we have 3 important provisions in this section that show that candidates have to be qualified. First, it requires that under 1203.
But the state Supreme Court unilaterally came to the conclusion that Trump committed a rebellion, but he never was convicted of that, and he never committed a rebellion. It was criminal activity that had literally nothing to do with anything Trump said. Trump has a right to be upset without criminal activity that has nothing to do with his words. He used the words without being linked to criminal activity. He used the words peaceful and patriotic. He's allowed to, you have numerous Democrats still believe that Trump was a Kremlin operative who stole 2016.
2A, that a political party that wants to participate has to have a qualified candidate. It also looked at the fact that comparable write-in candidates also had to be qualified.
No, but this isn't a write-in candidate, so we're actually talking about the participation of a political party, right? We're not talking about the participation of a candidate.
Sure. I think that the fact that the write-in candidate also had to be qualified was confirmatory of the fact that the political party candidate also had to be qualified. And it would be otherwise incongruous to read those things differently.
So how is Section 3 a qualification?
Under the reasoning of the Colorado Supreme Court,
no, just on its face.
A candidate must meet all the criteria for eligibility, and I don't perceive any distinction between meeting the eligibility criteria and not being disqualified. I just don't see any meaningful difference between those two things.
Thank you.
You represent the Secretary.
And then you fast forward to this.
Now we roll it, folks. This now is a Fox News alert, and reading this. The U.S. Supreme Court rules in favor of former President Donald Trump in his appeal of a Colorado ballot disqualification. That applies to Colorado. In all likelihood, it will apply to other states as well. Live to Shannon Bream for her initial analysis and reaction now. Did you have the inside word, Shannon? Hello.
Okay. So what we have from the court this morning is this decision in favor of President Trump. They essentially say the judgment of the Colorado Supreme Court that he could be kicked off the ballot in this manner does not stand, has to be overturned. Now, it's a per curiam opinion, which the Latin for that is sort of the court speaks. It's supposed to be sort of a unified voice. But we do, as I'm looking through here, have some additional folks who wrote, Justice Barrett, and I believe Justices Sotomayor, Kagan, and Jackson.
It was a unanimous opinion. Okay, all 9 justices voted against to overturn the Colorado ban. But then a couple of them just wrote their own viewpoint of what could happen possibly in another scenario.
They write concurrences as well, so they may have gotten to this in a different way, but I don't see any dissents here, so it sounds like the court as a whole is agreed that whatever happened with Colorado, it was not the proper framework to use here. There is discussion at the end of the main decision that says, there would be essentially a patchwork across the states. This was one of the worries that the justices had, and the questions that came together in argument were, what happens if we tell one state they can do this? The Chief Justice said, what if one state decides, okay, I'm kicking off a Republican, another state says, okay, I'm kicking off a Democrat, and then we get down to just a handful of states that actually have all of the candidates' names on the ballot. What would that do to this country? So it sounds like the majority of the court has come together in this voice to say what happened in Colorado is not correct. It sounds like they're saying states don't have this power, but essentially this is something that should be left to Congress. And so they agree to that point, but how they got to these different positions, how they got to the agreement, they found some different maps there, but they got to the same end result, guys.
So Shannon, I have 2 questions for you. One is about Sotomayor. She was considered to be somebody who might disagree. And also, does this mean that for any other state that is thinking about this, like Illinois, for example, that if they're thinking of trying to keep Trump off the ballot, that they would be barred from doing so based on this decision?
Yeah, what I've seen so far of this and trying to read through here, it sounds like what they're saying is the states don't have this power. So that would mean any state, essentially saying this is something that should have been left to Congress. If you're going to, there's questions, not to get too wonky, but about the 14th Amendment, if it was self-executing, if states could pick it up and say, we find someone we think was guilty of insurrection, and so we're saying they can't be on our ballot.
And that's what happened in New York. They said, we found someone who was guilty of a federal election crime. But the Department of Justice didn't say that. The FEC didn't say that. None of the federal government agencies or departments in charge of the federal laws, said that Trump committed a crime. So how can a state unilaterally decide, or state prosecutors or city prosecutors that are, by the way, in a city run almost entirely by the Democratic Party? That's another hilarious thing about all of this. Like, number one, a state cannot level a federal crime, a federal charge or indictment without the DOJ involved. But number two, it's like, they're like, well, there's no evidence of any partisanship. All of media is like, there's no evidence of partisanship. Everything is completely above board. Like, that's why Trump won the popular vote. Trump is the most honest president we've ever had. That would seem blasphemous to the wonderful, morally superior. Like, he lied 30,000 times in the Washington Post. Yeah, well, if you use that standard, If you use this standard the Washington Post utilized to come up with those 30,000 lies, Biden would have lied 60,000 times, or President Obama and Bush 90,000 times. Whenever Biden spoke, which was not often. But, like, for example, how many lies in the past 3 weeks? In the 3 weeks that Biden said he was staying in the contest, how many times did he say that? Okay, those were patently false statements. He was never going to stay. Okay, but the Post and others don't utilize that type of standard when it comes to Democrats. But he's the most honest president. He just goes ahead, says, yeah, this stinks, and you know what, we want a wall, we want this, and Democrats to me are like, oh my God, he said this, he said that, and they twist everything he says in the most disingenuous lie by omission, the most petulant lie by omission. Democrats in media have lied by omission for like 8 years, and then they pontificate about Trump lying. Okay, but the issue here, it just comes back to this, ladies and gentlemen.
Separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
They will get a chance to hear the case. They will get a chance to hear the case. Okay, Trump is not going to allow New York to sentence him. He's simply not going to allow the state of New York to, the conviction, the hush money conviction that should never have been imposed upon him. He's not going to allow that to be a cloud upon his presidency. So then, if he breaks some kind of parole, or who knows if he has some kind of parole or some kind of, supervision, some kind of period where he has to act a certain way or say certain things, or not talk about. I think that he's still under the gag order, where he might not be able to. He might still not be able to talk about Michael Cohen and Stormy and others. Okay, and so, but let's listen to this. This is the reason, ladies and gentlemen. Okay, right here.
Tougher than steer hide, stronger than any leather in your closet. Meet the Hanks Bison Club.
All right, so Trump's indictment looks like a perversion of campaign finance laws. There are no crimes committed, or at least that's what Bradley Smith, Capital University law professor, chairman, and founder of the Institute for Free Speech. Mr. Smith is a former FEC commissioner, and he's the co-author of Voting Rights and Election Law. Brad, you're writing in the Wall Street Journal. We've been trying to get our paws on you for the show. Thank you for coming on. You're saying there was no crime.
My pleasure.
There was no crime to start with. Even if there were some issues on the so-called filing of business papers, there was still no crime.
Right. I've had a bit more time. I had the commercial break to look at the indictment a bit more. And it looks like the last couple pages of the indictment do intend to say that the crime was not disclosing campaign contributions, although they never cite a specific government statute. But here's the problem here. The prosecutor's theory goes like this. Federal law says it's a campaign contribution to make an expenditure for the purpose of influencing a federal election. Those are the key words, for the purpose of influencing. And he says, well, these payments were intended to keep her quiet, which would help the campaign, so they were for the purpose of influencing the campaign. Now, first, these payments could have been made for other reasons, right? To prevent embarrassment to his family, to preserve marital harmony, all kinds of things. But none of that really matters, because the standard here for the purpose of influencing is not a subjective standard. It's an objective one. So if I go out and I want to pay for TV ads that say, Donald Trump is a ding-dong daddy from Dumas Bay, because I think that's really going to help him win re-election, it doesn't matter. Legally, that will not be for the purpose of influencing an election, no matter what my own subjective purpose was, right? It's subjective. So what counts as campaign expenditures? Things like, you don't hire a campaign manager unless you're running for office. Right. You don't take out ads saying vote for me unless you're running for office. You don't hire or establish field offices unless you're running for office. But other things you do. For example, you buy clothes, whether you're running for office or not. So the fact that I'm running for office and I say, I've got to look good, and I go out and I buy a $6,000 suit that I would never otherwise buy, doesn't make it a campaign expenditure. It doesn't count. Same if I say I need a $600 haircut. Or to take a more perhaps relevant example, suppose I'm a business owner and I say I'm going to run for office and I go to my corporate lawyer and I say, there's some lawsuits against our corporation. I think they're bogus, but let's get rid of them so they don't interfere with my run. Just settle those lawsuits. You can't settle those with campaign funds. It's not a campaign expense, even though that person's subjective purpose was to influence the campaign.
By the way,
so that's a very important part of the law.
I know. I was very impressed with the $6,000 suit. That must have been a custom bespoke suit.
The issue is that it's only a campaign finance violation if you purchase something with your own money or with campaign money that you would never have purchased if not for running for president. So the Steele dossier would never have been purchased by Clinton and the DNC were it not for Trump running. Trump could have, let's say he did have that, night with Stormy. He would have paid Stormy like anybody could have. Like during the trial itself, I think the publisher stated, oh yeah, there's a whole bunch of celebrities and high profile people that pay to silence romantic relationships all the time. They're not running for president. So paying Stormy, he could have paid Stormy with dollar bills. It wouldn't have been a problem. It's not a campaign finance issue. Nor would anyone change their vote from Clinton to Trump because of this, or Trump to Clinton.
In your op-ed piece, it was 4,000, but I know we've had an inflation problem in the last couple of weeks. But your point here, I'm just having some fun, but your point here, Brad, if I understand it, is that you buy a suit, you get a nice haircut, whatever, you're doing it directly for the campaign. Is that correct? That's the point you're making. But if you want to
the point is, yeah.
If you want to defend yourself, your honor, keep it away from your wife, that kind of thing, which, by the way, is unproven. I mean, Stormy Daniels keeps telling people she didn't have an affair. Nobody wants to listen to her, but that's It
doesn't matter if he did. It doesn't even matter if he told Michael Cohen to pay with dollar bills. It wouldn't even have mattered. It wasn't even a crime. That's if you could prove that he told Cohen, which, by the way, that's the presidential immunity. Michael Cohen is saying, oh yeah, when he was president, he spoke to me. Or no, sorry. Was it Hicks or one of the staffers? There might have been some information, evidence given when Trump was president speaking to Michael Cohen also. So, I mean, presidential immunity is involved there. But even if Trump is on tape, even if he's on tape saying, go and pay Stormy, Michael Cohen, because Michael Cohen actually started a corporation and paid with his own money. That's like, the whole thing is so hilarious. But even if he told Michael Cohen on tape, go and pay Stormy, it still wouldn't have been a campaign finance issue. Because he would have paid Stormy with or without a presidential campaign. That's the issue.
Perhaps grist for another segment. But if that does not qualify because it's not directly for the campaign. Is that right? Is that my correct interpretation?
It actually goes for that. Even though you bought that suit because you were running for office and want it to look good, it's still not a campaign expenditure.
Oh.
Why? Because you buy clothes. You buy clothes whether you're running for office or not, right? And so anything that people might do, even if they're not running for office, doesn't count. So people pay money. For example, they pay divorce attorneys to try to seal up their divorce records so that those don't become an embarrassment of the campaign.
Right.
Their purpose may be to influence the campaign, but it's an expenditure that somebody who wasn't running for office might also make. The only things that count are things that come directly out of the fact that you're campaigning. And the flip side of this is that it's actually illegal to convert your campaign funds then to personal use. So it's actually illegal to use your campaign funds to buy that suit. It's illegal to use your campaign funds to pay a lawyer to seal your divorce records because you think that will help your campaign. And this is the real problem you have here. Not only is there, I think, not a campaign finance violation, this underlying alleged violation, but it's a situation where they're going to get Trump coming or going, because I think, knowing Bragg, and you've set the political stage very well, had Trump paid for this with campaign funds, I think we can feel pretty certain that he would be being charged today with having illegally converted his campaign funds to personal use. In other words, they were going to get him coming or going. If he pays for it with campaign funds, they were going to say it was illegal personal.
And the statute also states that he has to know the FEC statute, knowingly break the FEC statute. The state prosecutors likely don't even know the statute themselves.
Use. If he doesn't pay this money with campaign funds, which was the reality, now they say, oh, well, he should have used campaign funds. And that's, the antithesis of the rule of law, where you set up a system where no matter what course of action a person takes, they're going to be held in violation of the law.
Well, I mean, but how does that get up to the Federal Election Commission, which has already turned this case down?
Like the John Yoo segment, this is the whole hour encapsulated, ladies and gentlemen, the whole live stream in 2 seconds.
Once.
Right. Well, this raises yet another question. Can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think about it this way. Imagine if New York just passed a law saying it is a violation of the New York Penal Code to violate any federal law. And then we'll decide what federal law is violated, right? That would subvert the entire federal state structure of law. I mean, that would allow state DAs to start prosecuting anything they think is a violation of federal law, even though the federal courts or federal administrative agencies or the Department of Justice had felt it was not a violation of federal law. So it's really getting into sort of wacky legal theories, but also I think very dangerous theories. Again, if we think about the rule of law, I don't think this can be emphasized enough that if Trump had paid for these with campaign funds, which the DA says he had to have done, I think they'd probably be chasing him today for illegal conversion of campaign funds to pay this personal expense.
And there you have it, ladies and gentlemen. Clarence Thomas and pretty much every conservative on the Supreme Court, I think the liberals also, have already, overturned the case. This is a clear-cut, I believe it ties in with the 10th Amendment, but this is federalism. What they've done is try to circumvent federalism. The Department of Justice did not level the hush money case against Trump. The Federal Election Commission did not level it. The federal government stayed out of it. The state government said, oh, he committed a federal crime. Can't do that. Cannot do that. That's blatantly unconstitutional. Anyway, ladies and gentlemen, thank you so very much. This will be 100% overturned. It essentially is already overturned. And they're just getting as many of the usual. And this is the best thing possible. Media has not changed one bit. And it's only making Trump stronger. Trump rails against justice system. CNN, he's very angry. This is only helping Trump. When you deviate so far from the truth, and everything is sensationalized, and still Democrats lose politically, and media loses essentially also, because they're after Trump 24/7. He's going to get a huge, huge victory in the Supreme Court again, and I'll be right again. And essentially, it's already taken place. The Supreme Court has essentially already ruled on this with the Colorado decision and the immunity decision. Both in favor of Trump. Huge victories. Anyway, hit subscribe. Thanks, everybody, to my Super Chat Paul. Everyone here, thank you. God bless you all. I should have a segment tonight. If not, I'll be here tomorrow. We did pretty well today. Thank goodness. And I just want to thank every new subscriber here. Hit subscribe if you just tuned in. And thank you again. I'll be back